Thank you.
Welcome back to the conference. Before we start, I would like to inform you that presentation materials used in this conference will be made available on the dedicated website of the conference, HCCHjudgmentshk.org. Our afternoon sessions will kick off with a discussion on the grounds for refusal under the Judgments Convention. We're honored to have with us on stage our moderator for the session, Mr. Peter Wong, Deputy Law Officer, Treaties and Law of the Department of Justice of Hong Kong, along with speakers Professor Peter Arnt NIELSEN, Professor Junhyok and Ms. Cristina FERREIRA. Mr. Wong, we hand the time over to you.
Thank you very much, and welcome back to this afternoon session. I know that it's quite difficult immediately after lunch but I think the interesting topics would provide a lot more food for thought. And I'm very honored to be able to moderate this session with three eminent speakers whom we all know, I think, from various occasions. And in particular, I'm going firstly to have Professor Peter NIELSEN joining us in this panel to provide an overview of the grounds for refusal under Article 7 of the Judgments Convention. This article is particularly important because it would take away effectively the right to enforce the relevant judgments if those grounds or discretionary grounds are complied with. So I think Professor NIELSEN needs no introduction, but we are fellow. We know that he's got high degrees from the Copenhagen Business School and also University of Cambridge, and he's specialized in private international law and international commercial law. So without further ado, let's invite Professor NIELSEN to do the presentation. Thank you.
Well, thank you very much, Peter, for your kind words of welcome and introduction. I'd also like to thank the organizers for inviting me and being able to contribute to this extremely significant occasion today. Now, the purpose of my presentation is to go through Article 7, which is the provision of the Convention that contains the rules on refusal of recognition and enforcement. Now, in order to understand that provision, it's necessary to make a few general comments on the structure of the Convention and on Article 7 itself. I also been asked to compare Article 7 of this Convention with the 2005 Choice of Court Convention and the Brussels I regulation on recognition and enforcement of judgments in civil and commercial matters. Now, on structure and context, it's really important to understand that this convention is a simple convention. Thus, it only sets up uniform rules on recognition and enforcement of judgments. Indeed, it has no uniform rules on jurisdiction. I mention this because this is important when we look at the rules on refusal of recognition and enforcement. On the other hand, as Cara emphasized in her presentation, the 2005 Choice of Court Convention is indeed a double convention. It has one uniform rule on jurisdiction, which purpose is to make exclusive choice of court agreements efficient. Then it has some rules on recognition and enforcement, and that's it. But in essence, it's a double convention. Now, the Brussels I regulation is also a double instrument. It has uniform rules on jurisdiction. It has a lis pendens provision dealing with parallel proceedings, and it has uniform rules on recognition and enforcement. Now, my final point on structure and context is that although we are celebrating the 2019 convention today, I think we should also celebrate the 2005 convention, because in my opinion, these two conventions must be seen as a package. Two instruments that complement one another perfectly well. Closer to the micro, yeah. Okay. Some general comments on the 2019 convention when it comes to recognition and enforcement. Article 4 is a basic provision. Contracting states must recognize and enforce judgments from other contracting states. So far, so good. Of course, we have Article 7 with the grounds for refusal of recognition and enforcement. But before we can actually discuss Article 7, it is necessary for any judgment holder to ensure that the judgment comes within the scope of the convention. And here you have Article 1 stating that the convention applies to civil and commercial matters. And then you have exceptions to that scope in Article 2, where you have a fairly long list with exceptions to civil and with exceptions to the scope of application. Now, the second threshold you have to pass in order to be able to discuss Article 7 is Article 5. And under Article 5, it is a precondition for recognition and enforcement that the Court of Origin took jurisdiction on a rule which is contained in the list in Article 5 and for exclusive jurisdiction in Article 6. But once you passed these two thresholds, you can then discuss the exceptions to recognition and enforcement in Article 7. However, please remember that Article 7 is only the floor, not the ceiling, as had been said earlier today. If under national law you have more favorable rules on recognition and enforcement, you are indeed, as a judgment holder, free to apply national law rather than the convention. Now, let's turn our attention to Article 7. Article 7 is a provision which has basically been copied from the 2005 convention, Article 9. They are more or less identical. And you can also see from the explanatory report that the list of exceptions in Article 7 is an exhaustive list. So there are no other exceptions. You will also see from the provision itself and from the explanatory report that there are 6 grounds for refusal. And under the convention, these exceptions may be applied, so the system is discretionary. It's not mandatory to apply one of these refusals. Finally, another point is Article 20, which I think in this context is a rather important provision. Now, here we have a convention setting up uniform rules. That is one thing. But another thing is to apply these rules in the same manner. If the system is to be efficient, we need to have uniform interpretation of these rules as well. And the purpose of Article 20 is exactly to ensure that judges interpret the provisions of the convention in an international spirit, looking at the need for uniformity. Let's turn to Article 7 itself. Now, the first rule on refusal of recognition and enforcement is 7.1a. In fact, that provision has 2 rules on notification. The first rule, 7.1a, 1, is a rule which has been agreed to in order to protect the defendant, or rather the judgment debtor, but here it must be the defendant. And the purpose is to ensure that a judgment can only be recognized and enforced if indeed the defendant was heard and had a full opportunity to present his case. Now, under 7.1a, a judgment can be denied recognition and enforcement if the document instituting the proceedings wasn't notified to the defendant in sufficient time and in such a way as to enable him to arrange for his defense, unless, of course, the defendant entered an appearance and presented his case without contesting notification. So this rule is, I think, a basic rule, a useful rule, and you find exactly the same rule in the 2005 Convention, and you find a similar rule in Brussels I, not an identical one, but a similar rule based on the same principle in Brussels I, Article 45(1)(b). The second provision on notification is Letter 2, and that deals with notification vis-à-vis the defendant in the requested state. And here the judgment can be denied recognition and enforcement if that service in the requested state is incompatible with fundamental principles on service of documents. Article 9 of the 2019 Convention doesn't really explain what the background is in relation to the words fundamental principles of the requested state, but if you compare with the Hague Service Convention, Article 13, paragraph 1, you will see that the question that can be raised here is a question of sovereignty or security. Let's turn to the next exception to recognition and enforcement. That's 7.1b, procedural fraud. Again, this is a provision which has been copied from the Choice of Court Convention. In Brussels I, you do not find a similar provision, and that is simply because within the European Union, we look at procedural fraud as part of public policy. Again, the purpose of this provision is to protect not really the defendant, but rather the judgment debtor. And a couple of examples that have been mentioned in the explanatory report is situations where a party is trying to corrupt a judge or a witness, or where a party intentionally conceals key evidence. So that's that provision. Let's turn to probably the most important exception to recognition and enforcement, public policy. Of course, public policy is a key element in any instrument on recognition and enforcement, so you find identical provisions in the 2005 Convention and in Brussels I, and also in the key instrument on arbitration, the New York Convention. Now, I think it's quite common to say that any exception to a general rule should be applied only on an exceptional basis, and I think it is also common to say that exceptions should be interpreted in a narrow and strict manner. And this should also be the case in relation to this concept of public policy. Now, what does it more precisely mean that we should interpret these exceptions or public policy in a strict and narrow manner? Well, I would say that public policy is a concept of its own. It doesn't cover the other exceptions in Article 7.1. So if you have a case, for instance, concerning notification, you have to deal with that issue under 7.1a and not 7.1c. Furthermore, on public policy, you can discuss whether public policy is a national concept, a uniform concept, or a mixed concept. If you look at the explanatory report to the 2019 Convention, it is clear that the starting point is that public policy is a national concept. On the other hand, it is also emphasized that we have a need for uniform interpretation and that we should have an international minimum standard for public policy. And in the explanatory report, you can see this quote, what would constitute public policy. So it must be a manifest breach of a rule of law regarded as essential in the legal order of the state of recognition and enforcement, or as a fundamental rule of law in that state. Examples, well, if you look at the explanatory report, illegal contracts are against public policy, fundamental rights are protected by public policy, so freedom of speech, for instance, which is explicitly mentioned in the explanatory report. Now, public policy will be discussed in our next presentation, so I will say no more about it at this point and move on to Article 7.1d. And here I will simply refer to Kara's excellent presentation on that provision, so we can in fact move on to the two final exceptions to recognition and enforcement of judgments. Those are Article 7.1e and d, and they both concern situations where you have conflicting or inconsistent judgments. Now, 7.1e deals with the situation where the judgment creditor comes with a judgment to one state for recognition and enforcement, and then in that state there is another judgment which is in conflict with the judgment holder's judgment. Here it is quite common to say that the requested state can refuse recognition and enforcement of the foreign judgment and give priority to its own judgment. You find that rule in the 2005 Convention, and you also find that rule in the Brussels I regulation. However, Brussels I is a double convention, and Brussels I has a strict rule on dependence that will, in case of parallel proceedings, cut off one of the two sets of proceedings. In most cases, it will be the proceedings instituted second in time that will be stopped, and then the proceedings first instituted will continue, and you'll get one and only one judgment. So in a double convention like Brussels I, we hardly ever see any conflicting judgments because the dependence provision is sufficient. Now, in this convention, national law governs jurisdiction. So in this convention, there is a much higher risk than in Brussels I or in any other double instrument that there will be parallel proceedings and thus, at the end of the day, conflicting judgments. But that's a risk of life when you agree to a simple convention like this one. Let's turn to the final provision, 7.1 F. Also the situation of inconsistent judgments, but this is a slightly different situation. Here you have a judgment from state 1, a judgment from state 2, and then each judgment holder will ask for recognition and enforcement of that judgment in member state 3. What should the judge do in that state? Under this provision, the judge will have to recognize the judgment first delivered. This provision only applies between the same parties and where the judgment is on the same subject matter. So the scope of application is somewhat narrower than the previous provision, 7.1 Again, this situation is more likely to happen in a simple convention than in a double convention because we do not have a direct dependence provision. Of course, in 7.1.2 we have an indirect dependence provision, but it has a narrow scope of application, and therefore it isn't. It's actually far from as efficient as the dependence provision we have in Brussels I. What are my conclusions on Article 7? Well, I would say that the provision is a fine provision. It contains exceptions to recognition and enforcement that are well known, both in the 2005 Convention and in the Brussels I regulation. So therefore, it's a well-known framework we have set up. Now, if you combine that with the obligation to interpret the convention in a uniform manner, then we are pretty close to having created something which really can be efficient at the global level. And finally, if you see the two conventions, the 2005 convention and the 2019 convention as a package, then I think we have created a framework that can compete with the New York Convention. Whether that will be the case or not is, of course, another question, depending on political wills in different states. But the framework is there. Thank you.
Thank you very much, Professor Nielsen. Thank you for the insightful overview of the refusal articles, in particular from a comparative perspective with the Brussels I regulation, also the 2005 convention. Our next speaker in the panel is Professor JANG, Professor Junhyok. He has high degrees from the Seoul National University, University of Chicago, and New York University. He has been involved and was involved in the HCCH judgment project since 2016. So may we have Professor JANG.
Distinguished guests and speakers, it is a great honor for me to be allowed to participate in this meaningful event as a panelist with the distinguished speakers and guests. Drawing on Professor Nielsen's excellent presentation on refusal grounds generally, I would like to add some preliminary remarks from my personal point of view, again, focusing on public policy. The broad question for me is how much uniformity can be realistically be achieved, and what specific functions can be expected out of the public policy exception to resolve some remaining issues. Regarding the substantive aspect of public policy, let me mention two possible issues. First issue is about relates to Article 10, which distinguishes compensatory and non-compensatory damages to exclude the latter from recognition and enforcement under the Convention. Opinions may vary on the underlying policy of Article 10. It may be a substantive policy of denying overcompensation or a conflict of laws approach of delimiting the territorial reach of non-compensatory damages. But the consensus to have Article 10 in the diplomatic conference was reached smoothly following the model of Article 11 of the 2005 convention. So any theoretical discussion about the underlying policy was not perceived as necessary. In Korea, for example, but however, some people criticizes the wisdom of Article 10, and because a Korean legislator has imported Article 10 to be part of national rules of Korean law, the critics also question the wisdom of the imported provision. The critics mention that the critics point to the growing tendency to provide for multiple damages in Korea, to question whether the policy against overcompensation may be part of the international public policy of Korea. But we should also note that there's an alternative explanation open, which is that Article 10 may be providing for a conflict of laws solution of limiting the territorial reach of non-compensatory damages, so that each country decides whether to issue and enforce non-compensatory damages for their own territory. So this policy may survive even though there are growing similarities across the border in substantive law policy. And the next question with Article 10 is where to draw the line between compensatory and non-compensatory damages. The draft explanatory reports makes clear that an autonomous interpretation should govern. And I also think this is totally logical. This is the question of the law of recognition and enforcement, and because the convention rules apply to the recognition and enforcement, convention itself should provide for the criterion. Whether the court of origin awarded compensatory and non-compensatory damages under separate headings, then the question arises whether this characterization may bind the requested state. But as the draft explanatory report explains correctly, it is the task of the court requested to distinguish between the two kinds of damages according to an autonomous definition, either in pursuance of an established criterion or in search of an autonomous definition to be built. On the other hand, there is a logical room for even compensatory part of the damages may be reviewed under Article 7(1)(c) public policy in very extreme situations. Actually, in my country, in Korea, some commentators tend to mention this possibility, but I should mention that this should be a very remote possibility, so that even in a very sensitive area, it would be better to focus more on distinguishing between what is compensatory damages and what is non-compensatory. Of course, it may happen that there come up some kind of defect of diversity in distinguishing between the two, but I think it is better to live with that factual or some practical diversity rather than allowing a frequent resort to Article 7(1)(c). Let me now turn to injunctions, where the extraterritorial part of a foreign injunction concerns a behavior in the requested state. The territorial nexus requirement for public policy intervention will be easily satisfied. As a result, the extraterritorial portion of an injunction may run a higher risk of refusal in the state that is directly affected by it. This may appear as a stricter review of extraterritorial effect as opposed to intraterritorial effect, but personally I should say that the standard of review remains the same, and the apparently different treatment comes solely from the territorial nexus. And in the next slide, I would like to talk about a procedural part of the public policy. In some states, including Germany, if I understand correctly, the prohibition of abuse of right applies to the law of jurisdiction as well. Unlike the 1980 Convention on Contracts for the International Sale of Goods, the 2005 and 2019 conventions are silent regarding the possibility of gap filling by general principles of law, which may include the principle against abuse of right. Therefore, the availability of this defense is left to interpretation. Logically, there may be, I think, three possible answers. First, no review on this issue. Secondly, reading some inherent limitation in the convention provisions on indirect jurisdiction, And thirdly, allowing public policy to intervene. Personally, I would prefer the second solution. But in case the law of treaties would be a bar to a flexible interpretation of jurisdiction filters, then I think the public policy exception of Article 7.1c would have to intervene as the last resort. Next issue I would like to talk about is Article 7.1e and f dealing with inconsistent judgments. Article 7.1e provides for the inconsistency with a judgment of the requested state. Even a later judgment may satisfy this defense. So it could be particularly a sensitive issue where such judgment of the requested state was obtained during the process, during the time when the recognition procedure for an earlier foreign judgment was continuing. Here, as a possible solution, one might argue that Article 7.1e is only a manifestation of the idea of procedural public policy, so that a domestic judgment, which is not much worthy of priority, should not constitute a refusal ground. Next issue is Article 7.1f, which adopts the first in judgment rule, subject to an important proviso. Suppose State A issues an earlier judgment, but an appeal procedure continues, and then a later judgment in State B becomes unappealable. Let's suppose State C systematically invokes Article 4.4, requiring postponing or refusing recognition and enforcement until the ordinary appeal becomes no longer possible. The apparent intention of Article 7.1f would be to recognize the earlier judgment under some condition, but if we read Articles 4.4 and 7.1f in a strictly grammatical manner, State C could end up recognizing the later judgment of State B. And this may be perceived as an ironical result, and it happens because Article 7.1f contains a condition that the earlier judgment fulfills the conditions necessary for its recognition, and Article 4.4 works to constitute the conditions as mentioned in Article 7.1f. And how do we solve this problem? Perhaps Article 7.1f could be interpreted a little differently from its language, or public policy exception of Article 7.1c could be invoked to deny recognition to the State B judgment, so that State A judgment could be recognized in State C. It's a little bit complicated, but it is always a question of whether we introduce some flexibility in interpreting some comprehensive convention rules, or we have to fall back on the public policy exception as the last resort. This is my last slide, and let me now turn to Article 7 to discuss two further points in Article 7, which is burden of proof and judicial discretion. The language of Article 7 appears to suggest that the burden of invoking and proving any refusal ground is on the party resisting recognition or enforcement. But if we look at the draft explanatory report, it remains silent on this issue. And personally, I think this procedural issue of regarding burden of proof is not touched upon in this convention, and therefore left to the law of the requested state as another issue of procedure of the requested state. The last issue I would like to talk about is the meaning of Article 7 discretion. Article 7.1 Chapeau uses the language may be refused. In fact, this language is already used in the New York Convention of 1958, and state practice varies. Some say this should be a discretionary refusal mechanism so that every state has to give discretion to the courts. Some say this means some idea of bounded discretion so that in individual cases, courts may be bound to refuse. To give my personal view, I think the discretion is given to the court of the state requested, not the court requested. The convention says some discretion should be given to the state. So each contracting states can choose from either giving full discretion to the courts or mandate refusal in the presence of the refusal grounds as provided in the convention. And one similar question could also be asked in interpreting the discretion in Article 4.4. But interestingly here in Article 4.4, the language says the court addressed may, instead of saying recognition or enforcement may be refused. But it is my personal view that although different expression is used, the requested state may give full discretion to the court or even invoke Article 4.4 in a more systematic manner. For example, if the requested state issues an implementing legislation that says in the presence of certain until the judgment becomes unappealable, recognition and enforcement should be postponed or denied. Some others may disagree, saying this is not very friendly to recognition and enforcement. But at the same time, by having such implementing legislation, we have more clarity and more consistency. And states can also, I think, establish a certain pattern of judicial practice. And this is all, and I was asked to focus on public policy, so I had to search for every possible issues that I think may arise with public policy. But as a conclusion, I would like to say that some flexibility in interpretation of convention provisions may be first pursued, and then as a last resort, there may be some remaining issues that have to rely on public policy exception. Thank you very much for listening.
Thank you, Professor Yang. We know that public policy has always been a very difficult concept, and thank you for raising a number of interesting, intellectually stimulating issues centering on this concept. I'm pleased to invite our final speaker, Ms. Cristina FERREIRA from the Macao SAR, to present the topic recognition and enforcement of judgments in the MSAR and the impact of the 2019 Judgments Convention in the MSAR. Cristina and I were part of the Chinese delegation in the diplomatic conference, so I'm particularly pleased that she will talk about the impact of this convention from the inter-regional perspective. Thank you.
Thank you. Thank you very much. First of all, I have to thank the organizers for inviting to come here to speak about this topic. And I also have to send a word of appreciation to the members of my panel. It's an honor to be here, especially be on the public law, to share some views with people from the international private law where this convention is going to work with. I also want to say a word to thank you to two colleagues of mine, Duarte Chagas and Rui Cascão, with whom I had some wonderful discussions about this topic and how I would address this topic for this conference. So my idea is to pick up the topic of grounds for refusal, a bit of public policy, which is the theme of our panel, and maybe to cross-border to the next panel that is about cross-border relations, in which way this convention could be useful. So in that perspective, I will talk about how judgments are recognized and enforced in Macao, and also to give a perspective in which way this convention is useful for Macao, and also in the context of interregional integration or cooperation. So first of all, let me speak about a bit of Macao. Not everyone is familiar. People from Macao and Hong Kong we are, but expecting a bigger audience. I must say that Macao is part of China. As such, we cannot be part of conventions that only bind states. So naturally, and most of the Hague Conventions only bind states. So for the conventions to be applied in Macao and Hong Kong HCCH, they have to be extended. So China, when it binds itself and ratifies a convention, it has to say if those conventions, or in this case the 2019 Judgment Convention, is going to be applied to Macao and Hong Kong. It's important to say also in this context that we are part of China, but Macao and Hong Kong, they have their own special legal status. So we have a high degree of autonomy. We have executive, legislative, and also judicial autonomy, including of last adjudication. So which means that we have that high degree of autonomy is reflected in another area. We have legal and judicial autonomy. Means that we have our own law and we have our own court system. In Macao, we have a three-layer court system. We have the last instance court, the second instance court, and the first instance court. So for the convention to be applied to Macao, it has to be extended. The Hague Convention, the judgment, as well as other conventions of the Hague, they have specific provisions in relation to countries which have more than one legal system, as we just heard this morning by Kara speaking about Australia. So we have Article 22, 25 and 28 specifically that address this issue, and they also explain that especially how to make the interpretation of this convention and the application of this convention in relation to these states which they are multi-system or they have multi-legal systems. So wherever it speaks about a court of a state, we have to understand that it will be applied in relation to the territorial unit of that state that is being bound to. Whenever we speak about law and procedures, it has to be understood within the context of that territorial unit, and whenever speak about the connecting factors, the factors of connection, we also have to take into consideration the ones that are in those jurisdictions which the convention is applied to. So in Macao is a civil law system, which means that written law is the source of law. Case law is not non-binding, different from Hong Kong. And a convention to be implemented in Macao, such as this convention, to have effect, legal effect in Macao, it has to be published in the official gazette. Only that it requires legal force internally. What is the position, or what is going to be the position of this convention in Macao within the hierarchy of the sources of law? It will be in the middle, I will explain. So for us, on the top of the hierarchy of our internal hierarchy of sources of law, it's the basic law, which is our fundamental law and has constitutional value. Afterwards, it is international conventional law and then ordinary law, which means that this convention, if it is applicable to Macao, it will have a superior value over the ordinary law that we have in Macao. What is the impact in relation, what this means? This means that, for instance, we have in our Civil Procedure Code specific provisions in relation to recognition and enforcement of judgments, of foreign judgments, but of course the provisions of this convention, in case it is applicable to Macau, it could be extended to Macau, the rules, the procedures, the provisions of this convention will prevail over our local law, including our civil procedure code. So I decided also to show you some of the key conventions that we have applicable in Macau related with this topic on civil and commercial matters. We have the New York Convention, we have the Hague Service Convention, and we have the Hague Evidence Convention. And with interregional, at the interregional level, we also have with mainland China a judgment convention for recognition and enforcement, and as well with Hong Kong. We also have, with Hong Kong we don't have yet. Hopefully we will have. We have an arbitral awards, recognition and enforcement of arbitral awards with Hong Kong. Nevertheless, Hong Kong, as it was said this morning, already has a judgment convention with agreement with mainland China. So there is already an interregional agreement between mainland China and Hong Kong in regards the enforcement and recognition of judgments, which is quite useful as for the reasons that we heard this morning. So in Macau, we have key provisions in our civil procedure code, and the process for recognition is called exequatur. So what we have is a formal review. We are not going to analyze the merits, which goes much into what the convention is asking the contracting states to follow, which is not to analyze the merits of the convention, but to focus on the formal issues which are established in Article 7 regarding grounds for refusal. So, our procedure in Macau is the following. The Court of Second Instance is the entity that is going to analyze ex officio the grounds for refusal. From the decision from the Second Court of Instance, we can have an appeal to the last Court of Instance, and the entity that is going to enforce the judgment will be the First Instance Court. So the court is going to analyze all the grounds for refusal. And if you can see on the next slide, thank you, on the next slide, the grounds of refusal that we have in our civil procedure code are exactly the same that we have in the convention, in Article 7. So which leaves me in a very comfortable way to say that for us it's going to be very easy to apply the convention in Macau because the grounds for refusal are exactly the same. So I'm not going to extend too much on them since they have been already addressed. What I can say, for instance, in relation to the exclusive jurisdiction of Macau, that we have in our Article 20 of the Civil Procedure Code that when a judgment is related to property, rights in rem in Macau, we have exclusive jurisdiction, as in many jurisdictions in the world, rights in rem. It's an exclusive part that states would not give up, will not abdicate for sure. And also insolvency and bankruptcy cases where legal persons are involved that are Macau residents who have a domicile in Macau. For those legal persons, case in insolvency and bankruptcy, we also have exclusive jurisdiction. But this, again, it's also within the framework of the convention. So the limitations that we have in our jurisdiction in our general law also fit in the limitations that we also have in the judgment convention. So how all the grounds that are provided for in Article 7 of the Gentleman Convention are also in our article of 1,200 of the Civil Procedure Code, which are exactly the same. What I can highlight is that how can this be challenged? So the formal requirements can be challenged. The burden of proof lies in the oppositor, the person that is going to defendant or the person that is going to oppose the recognition. So the claimant will make a statement for the recognition or for the judgment to be rendered and to be executed in Macau, but it will be up to the other party to object, and the burden of proof will lie on that part. So the court will do the ex officio check-up list of the grounds for refusal. So the burden of proof lies on the party that's going to object the arguments of the first party that is asking for the recognition. So this is our system, which in many ways, for some professors, saying it's a very liberal, flexible, because it's not so time-consuming, since the opposition, it has to be the one coming with the arguments, saying that there is grounds to refuse and not to recognize or not to enforce that judgment. So what happened in Macau in relation to the public policy? So we have some court cases regarding where the public policy ground for refusal is raised. What I can say is that from the data that I have in the court, from the website, we know that we have 561 cases that were concluded in Macau since 2000 until July 2019. Now, if you ask me, are they related to arbitral awards recognition or to enforcement of the judgments? I don't know, because the court doesn't say so. Are related to civil or to commercial? We don't know. We have to look at all of them. So since I didn't have no time to look at all of them, but just some of them, I'm going to base my intervention on a study that was made by Professor Tu, that generally all the cases that we have been having in Macau for recognition of judgments, either arbitral or judgments coming from foreign courts and interregional including, are from family issues and successions. Basically, what we have is cases on family issues, a lot of them for recognition. This makes sense if you look at Macau as a central city full with people from many, many nationalities and working in Macau and living in Macau. So even regarding the policy, regarding the public policy, the definition of our court follows very much what Professor Peter just said about the core essential values of a society. And the public order has been used sometimes together with the procedural fairness. Because for us in Macau, procedural fairness is not only a procedural principle, but it's also a substantive principle of law. So for us, access to law and due process of law, it's not only something that we need to take care as a formality and a regularity issue that need to be confirmed, that the defendant was heard, that the means of defense were provided, but it's also a core principle of our internal law. And so we have to check if the defendant had, apart from the means of defense, if he had access to translation, if he had access to legal aid. So there is a kind of a package of other issues that are within the due process of law and procedural fairness that we have to check. And many times it is linked also to the public policy ground for refusal. So sometimes there is a mix between the justification of public policy together with procedural fairness, because it's also considered as a basic principle of our legal system. So it is, all the public order is, ground of refusal is also expressed in other provisions in our legislation, such as the Civil Code, the Civil Procedure Code, and it's also, and as I explained regarding the access to law, we also have in our basic law as a fundamental principle of the citizens and residents of Macau. Apart from this, if I want to give you a case law experience of where public policy was raised, what I have is a civil law case regarding a family issue, because in fact we haven't yet had any case regarding to civil and commercial within the context of this convention. But if I want to tell you, I can explain to you very briefly. It was a case where a Hong Kong couple decided an adoption case, and the adoption case was accepted, so the decision was done, and it was recognized in Macau. The problem was, only partially it was recognized in Macau, because the other part was not accepted based on the ground of public policy, and was that one of the progenitors, one of the parents was the biological mother of the child. And according to our legal system, you cannot adopt your own child. So in that perspective, that part of the sentence of the judgment was not recognized, but the judgment in relation to adoption had effect. But that part was based on public policy. So just to give an example how things work in Macau. So now I would like to go to another perspective, which is in which way this convention could be useful to Macau in practical terms, and due to the context of Macau, and another perspective in the interregional. So in local terms, Well, for Macao, it's really important to have a convention for the many reasons that were said this morning, for the advantages, cost benefit, predictability, legal certainty, especially when you are a city that you have 30 square kilometers, when you have a kind of 3 million tourists per month, which all the relations, the legal relations that can happen in those 1, 2 days, 3 weeks. So we have a lot of visitors. We are jurisdiction of gaming, where the gaming industry is the most important share of our income of the government. We are tourists, so we have the UNESCO site privilege also of being nominated, enlisted, and we have commerce, trade, and MICE, the industry regarding meetings, incentives, conference, exhibitions industry. So we are a service provider city, and a lot of construction work, lot of suppliers. So there is a lot of legal relations on civil and commercial matters that can arise in this city with 660,000 people and of many nationalities around the world. So of course for us is advantage. So we all of us, we see as a very good, it is very important this convention to be applied in Macau. However, I should say something in regards to the public policies, that you look at the convention, you see, and you know, being Macau a city of the gaming industry, you will think that, okay, gambling debts are included in the scope of the convention. Yes, they are, but not in Macau. Because in Macau, we have exclusive jurisdiction in relation to gambling debts. So which means that any situation that it comes internally, that is, if someone that according to the law may provide credit to someone that wants to play in our casinos or in our area of gaming, our laws are very strict. You can, but if there is a conflict between the debtor and the creditor, that issue has to be solved in Macau. So there's a clause in all the contracts of the concessionaires and the junkets that any conflict that may arise regarding claiming your debt, we have exclusive jurisdiction. So which means that in this area, we will be very happy to recognize any debt or to collect any enforcement, any judgment that you have, as long as it's not connected with Macau. Can be in the US, can be in Philippines, can be elsewhere, but in relation to Macau, we have our exclusive jurisdiction. It's interesting also to look at this in another perspective, which is, on the other way, we have an agreement, an interregional agreement with mainland China. And as you know, I think that for who doesn't know, gambling is forbidden in China, in mainland China is forbidden. And there is already a case where someone, a creditor, tried to claim a debt in Macau in relation to gaming in mainland China in Shenzhen court. This was not accepted because on grounds of public policy. So for China, gambling is a crime, lending gambling is a crime, so which means that if the mainlanders go to Macau and play, whatever debts they have or whatever credits they may have, they cannot claim in mainland China. And for them to claim in Macau, they also have to follow, the credit has to be given within the law, and within the law that allows lending of money. Otherwise, it's also illegal. So you can see here how public policy may work and how interregional arrangements that we have with Macau and mainland China can work in some area, but in other areas they may not work because of the public policy grounds. So how do I see this as a possibility for interregional? As you know, Macau now, it's within a new project. We have a new project, mainland China embraces with a new project, which is the Great Barrier Project. It is Guangdong, Hong Kong and Macau. Guangdong province, which entails 9 cities, plus Macau and Hong Kong. In this project, that in fact it's a kind of a small mini project of regional integration. And this project means flow of capitals, flow of products, flow of persons, means labor, new employment situations, flow of capital, investment, business, establishment. The idea is to create in this area, it's a kind of a small regional integration phenomena. So how can this convention be useful for us? First of all, the convention cannot be applied to Macau, Hong Kong, and China. For that, we need to make an interregional convention, because the convention is applicable to states, which means that it will be curious. We think, oh, the convention is applied to Macau, Hong Kong, and mainland China, so it's okay. They can use the convention. No, we cannot. We cannot use the convention. So we need to do a new legal instrument. Now, does it make sense to make a new legal instrument? Because Macau already has with mainland China, Hong Kong already has with mainland China, we don't have yet with Hong Kong. Does it make sense? Yes, it does. Especially when we have this new strategy. We heard about One Belt, One Road initiative. We also know that if we are going to have more flow of legal relations, we are going to be more litigation as well. We have going to have more and more mobility geographically, but also conflicts will arise. And it's important for the same reasons that were said this morning, that in case of predictability, legal certainty, cost benefit, it makes all the sense that this convention can be used as a model, as a source of inspiration for Macau, mainland China, and also Hong Kong. Now, the issue here that I want to leave at finishing my presentation is, so how is going to be the articulation? Because imagine that we are going to have an interregional convention, agreement in this case, an interregional agreement that is going to bind these three jurisdictions, that will create a framework for these three jurisdictions. At the same time, we already have bilateral interregional agreements. So we have to articulate them. Should we give priority to which? Because they have the same legal value. So we have to establish also a rule regarding the relationship between all these interregional instruments. Should we prevail the one that will bind the three jurisdictions over the ones that are bilateral? This is how to articulate these three jurisdictions within this framework. On the other hand, I think the rule of exclusive jurisdiction and also the public policy rule will have a role in this new interregional, I'm already saying it's new, on this scenario that I'm creating, because the rule, the public policy order, and also the exclusive jurisdiction will be important for each jurisdiction to maintain their own characteristics that they have also to be safeguarded. So we have also to think about that. Another thing that I would like to raise here is, should we think about an interregional agreement covering all over spectrum, mainland China, Hong Kong, and Macau, or should we have some special provisions to speed up procedures within the Great Bay Area zone? Because clearly, in this Great Bay Area, we are having a must-speed here, so can we have a two-speed convention agreement? Because for sure, in the Great Bay Area, the way we are building it, it's much useful, and it's kind of urgent that we need to have a tool where judgments are going to be recognized in order also to protect the parties, and also to ensure progress and development and economic growth. It's important to create mutual trust. Or should we have an interregional agreement only within this part of mainland China, just the Great Bay Area? As we have created an interregional agreement for the Great Bay Area, should the Great Bay Area also just exclusively create a mechanism faster for the recognition of enforcement of sentence within these 9 cities plus Hong Kong and Macau? Question mark. I'll leave you for food for thought. Thank you.
Thank you very much, Cristina, for the food for thought. I think in particular for our Solicitor General, I think he's been responsible for negotiating on the bilateral arrangement with mainland China. So now some more ideas. And I know that we've got about 12 to 12 minutes for Q&A session. I just wonder if there are any questions from the floor, given that we have quite a lot of interesting ideas here. I would propose, if time permitting, to invite actually Professor NIELSEN to spend a couple of minutes on some examples about public policy in the European context that would sort of inform our discussion perhaps a little bit further. So if I may invite Professor NIELSEN to talk a little bit about, give us a few examples of how public policy is applied in the European context. Thank you.
Well, I can give you one example on public policy from the European Court of Justice. But may I say from the outset that the Brussels Convention is from 1968, and when the Brussels Convention was signed, it was pretty clear from the explanatory report to that convention that public policy was a national concept. Now, in 1998 or so, the European Court of Justice came with a judgment on public policy, and the judgment is nicknamed the Kronbach case, case C7 from 98. Now, in that case, a German national had lost a case in France, and the French judgment holder took the judgment to Germany for recognition and enforcement. Now, during the proceedings in France, Kronbach didn't get a fair trial. So he asked the German judge to deny recognition and enforcement of that judgment in Germany. And under German law, the right to a fair trial was secured, I think, by the Constitution. So clearly, according to German law, the judgment should be denied recognition and enforcement. Yet the German judge asked the European Court of Justice, can I refuse recognition and enforcement in this case? Now, the European Court of Justice started by saying that public policy is a national concept. So with that remark, all member states were pretty happy. But then the court moved on and said, however, it is up to the court to set the limits of public policy. And in addition to that, the court also added some guidelines as to how a national judge should exercise this discretion. And the guidelines are pretty similar to what you find in the explanatory report on the 2019 Hague Convention. So what is the situation under the Brussels system? Well, some people say that public policy is a mixed concept. The starting point is national law, but the limits are set by the ECJ. Other people would say that, well, yes, but public policy within EU law is a uniform concept because it is the ECJ that sets the limits and decide whether you as a member state is inside or outside. Furthermore, the guidelines have been set by the ECJ. So clearly, within the European Union, you can certainly argue that we have a uniform concept. Now, what does all this mean in relation to our convention? Clearly, it seems to me that there is a need for a high degree of uniformity. National concepts are, of course, necessary in a global convention. But at the same time, we need to strive for a high degree of uniformity. And we had exactly the same issue with the New York Convention in relation to public policy. Over the years, I think there's general agreement that within the New York Convention, public policy is an internationalized concept. And that's why the New York Convention works so well, maybe.
Thank you. Thank you, Professor NIELSEN. Perhaps I would open the floor to the participants here to see if you've got any questions. I note in particular, actually, from Article 7.1c of the Convention, it refers to specifically infringements of security or sovereignty of the state. So that, in fact, is an express elaboration of the concept of public policy in the context of the 2019 convention. But this concept, security and sovereignty, is not a new concept. I think it's mentioned in the Hague Service Convention already, and it's recognized that it is a subset of public policy. And in Article 7.1c, it qualified this concept of public policy by the phrase manifestly incompatible with public policy. So it's meant to be narrowly construed. So in a way that protects the integrity of the grounds for refusal, particularly in the context of public policy. So this gentleman, I think that's a question.
Thank you very much. I'm El Balti Belir from Osaka University, and I would like to jump on this last point about security and sovereignty. You rightfully said that this notion is mentioned in the 1969 Convention on Service, but that was a time when sovereignty is a quite important notion in the recognition and enforcement of foreign judgments. And many states used to have a restrictive regime on the recognition and enforcement of foreign judgments. And I'm a little bit puzzled by this notion in the 2019 convention to have this kind of notion, because it will certainly lead to kind of excessive use, especially by countries who are not familiar with recognition and enforcement of foreign judgments. And especially, I'm not aware of any, let's say, national legislation that include these notions. Probably there are two examples in my mind, one in China and the other in Russia. Except these examples, I'm not aware of any kind of national codification that includes this notion in the context of public policy. Then my question is how these notions were could be, let's say, included in this draft. In this convention. Thank you very much.
Thank you very much for this interesting question. I think I would need assistance from my three eminent speakers. Shall we invite Professor JANG to start off?
Thank you for allowing me to mention again, intervene again. Where, as far as I understand, at some point of negotiation or throughout the negotiation process, the countries, the states which participated noted that the physical torts were covered, and there may be governmental torts, so that state interests may be involved, and this is a convention which does not cover all of civil or commercial cases, but interestingly, from some point of view, it may look like mainly for use in those traditional physical torts and others, and that may be one background, I think. Thank you.
Yes. Professor Cristina, you've got any points to supplement?
Yeah. Yes, I have. Now I will do the disclaimer as Emma did this morning. All my comments here are just strictly personal. And, well, to be honest, I'm not very fond of this introduction of these two possible or security and sovereignty said in this paragraph. I know that in some Hague Convention it was introduced, not in the same way it is written here now, but it has been. But in other conventions it was just a public order, ordre public. I don't like the word public policy, I have to say. Being from a civil law country, public policies, it's very much linked to the government and public. So I really like to use the word public order, I have to say. And if you go to the French version, you always see ordre public. And I also see from the Hague Conventions that in the beginning was public order, and just then it started to change public policy. I don't know if this change is good, honestly, for reasons of interpretation depending on the jurisdictions. But nevertheless, in relation to, honestly, when this was discussed, I already thought that security and sovereignty can already be inserted in the public order, because you can use the public order and you don't need to explain it, what reasons are, because most of the reasons can also be on the interest of the state. So for me, it's assume it's included already in the public order. We don't need to be go into much detail. But again, when we are negotiating instrument drafting, we are surrounded by countries with their own agenda and also their own political reasons, grounds, and we have to discuss and we have to find consensus. And so this was raised, and the consensus was established in order to find a way that would accommodate all the jurisdictions or all the countries that were in the conference room, but also in the diplomatic session, but also to ensure that this convention can be ratified and can be and to be enforced globally. I have to say, for instance, in the grounds for refusal between Macau and mainland China, and also Hong Kong and mainland China, the wording that he used in relation to this topic is the following. Can be, if it is contrary to the fundamental principles of basic principles of law, or the public interest of the society of mainland China, or to the basic or fundamental principles of law, or the public order of Macau, or the public policy of Hong Kong. So you see, also at the interregional level, we use more the standard and more classical, if you want to say, traditional approach than the one that was chosen for this convention.
Thank you, Cristina. I think certainly right to point out that the provision is the product of compromise among states, but it's quite clear that it's mentioned in Section 713 that the broad principle is public policy, and it refers to certain situations and use the word inclusive, including, so various situations, and it's explained, as I recall, from the explanatory report, that because unlike the 2005 Choice of Court Convention, there may be more occasions for possibility of invoking this ground in the context of security and sovereignty because of a wide range of subject matters covered. But ultimately, this is really governed by this broad principle of public policy. So I know that time is running out, but I like to invite my colleague, Professor NIELSEN, to perhaps if you've got anything to supplement before we conclude, round up this session.
Yeah, I think you're quite right, you and Cristina, that these words were added, and you're also right, they're absolutely superfluous, but it was part of a compromise. So in the explanatory report, it is actually as a compromise on the compromise stated that yes, those words were added, but it doesn't change the substance.
So with those remarks, I suggest we give a big applause to our three eminent speakers. Thank you very much.